Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing family-based immigration, so fiancé visas and marriage visas, the K-1, the K-3, the CR-1, and the IR-1 visa, which are either immigrant spouse visas, a non-immigrant marriage visa, or a non-immigrant fiancé visa. What happens when one of those types of visas is denied based on a legal ground of inadmissibility? What is a legal ground of inadmissibility? Well, there are legal grounds of inadmissibility set forth in the Immigration Nationality Act of the United States. They set forth certain activities, whether convicted of a crime or not, just participation in some activities is enough to be considered inadmissible, to the United States. So for example, prostitution, crimes involving moral turpitude, prior overstays, certain types of convictions in foreign jurisdictions for any of the crimes aforementioned, as well as certain types of drug crimes, including for cannabis, by the way, as the law currently sits. Any of these matters, if one is deemed inadmissible at an immigrant visa or a K-1 visa interview, or K-3 visa interview for that matter, if one is deemed inadmissible, one's visa application will be denied. So what is then the remedy to deal with the legal ground of inadmissibility? And that remedy is the I-601 waiver. So it is possible to get the denial waived, the denial based on a finding of inadmissibility. It may be possible to get that finding waived and thereby ultimately get the visa issued. Now, this is a rather more cumbersome process than just standard U.S. immigration. For those who believe that they may be the subject of inadmissibility, it's a very good idea to contact a legal professional, gain some insight and guidance into how best to proceed, but understand the overall process of dealing with an I-601 waiver is more time consuming than dealing with just the general process of obtaining a visa to the United States. I have done a number of waivers over the course of my career. I've assisted a number of clients with the waiver, and waivers are tough. Waivers, the packages are like this thick. They're like a phone book associated with waiver of inadmissibility to the United States. And in many of those cases, the legal arguments are quite discreet and oftentimes quite complex in order to overcome the prior denial. So again, those who are looking at if they believe a ground of inadmissibility exists in their case, or they've already been denied and are looking for a remedy to that denial, it may be a good idea to contact a legal professional, gain some insight and guidance into how best to proceed.